Hello, my name is Denise Antolini. I'm an Associate Dean at the William S. Richardson School of Law at the University of Hawaii in the United States. I'm also the Deputy Chair of the World Commission on Environmental Law, a position that gives us an opportunity to present this video lecture series today to share with our members and everyone else interested in environmental law and developments in countries or around the world. So it's my great pleasure to present one of the lectures in this series. Let me introduce the topic that I'll be talking about today, which is about the development of an environmental court, a specialized court in the state of Hawaii. I want to share with you how this court was developed, some of the strengths and weaknesses of this development, and I guess a lesson of inspiration that we hope will be shared with other jurisdictions around the world that are considering environmental courts. So first, let me tell you a little bit about the state of Hawaii. I hope that many of you have visited Hawaii. It's a very special place. It's the most isolated group of islands in the world. It's between Japan and California. So when you live in Hawaii, to go anywhere, you'd have to travel about 5 hours by plane. It also means that it's a biodiversity hotspot, and some people say that it has more biodiversity than the Galapagos Islands. Darwin may take issue with that, but in Hawaii, we're very proud of the fact that we have a high number of endemic species that are found nowhere else in the world. We have species that are going extinct, unfortunately. And so we have a lot of pressures in Hawaii because of development and tourism and just the number of people that live on the islands that are pressuring this really special environment. So we have a very small population in the islands of about 1.4 million people. So compared to most cities around the world, that's very small. But the number of tourists that enjoy coming to Hawaii every year is over 9 million people. So combine that with the fact that people love to live in Hawaii, there's a lot of coastal development, we have a lot of pressures on our ecosystems. So in general, let me talk about how the environmental court developed. It really developed because of this need to protect the natural beauty, the biodiversity, and all the natural resources in Hawaii from too much pressure from our population and development. So we have really good legislation in the state of Hawaii protecting our land, air, water, and our cultural resources. So the legislative framework is very good. Over the years, unfortunately, the government has been underfunded and understaffed in terms of its ability to enforce our environmental laws. And that has led to a real problem with violations. So we had a breakdown in the enforcement process, and it really was a question of would the judiciary be able to step in to assist to make sure that the legislation and the legislative branch, the executive branch, and the judicial branch all were coordinated to better enforce our environmental laws. So the history of our environmental court in Hawaii really goes back to a group of citizens, a non-governmental organization, a very small group of dedicated citizens on the island of Maui who decided that it was time that Hawaii step up and provide specialized training and specialized court to protect our natural environment. So that started about 12 years ago. And this very small citizens group kept going to the state legislature and asking for an environmental court, looking around the world at examples at growing environmental courts around the world and asking why doesn't Hawaii also move forward in this direction. And ultimately, because unfortunately things were getting so bad with enforcement and prosecution, the state legislature in 2014 finally passed the state environmental court. This is a huge development. We are only the second US state out of all the states to have an environmental court. The other environmental court in the United States is in the state of Vermont, and it's been around for quite some time, but it focuses on land use and zoning issues, so more municipal or city level issues. So Hawaii's environmental court is unique. Let me describe some of its features. First of all, the way it was created in 2014, the very first thing that the legislature did was delay implementation for 1 year so that everybody could really think about how the court should be implemented. So the legislature appointed what was called a judicial working group, and from the highest levels of our state Supreme Court, and said that this working group should look ahead and try to figure out exactly how our environmental court would be set up before it was implemented. And that's a feature I want you to remember in terms of implementing environmental courts. It's important that they be phased in and the mechanics of how it work be thought about in advance, perhaps rather than just an immediate implementation. So I think that's one of the things that our state did well in terms of starting our environmental court. That gave the judiciary an opportunity to speak to the lawyers who would be involved, start to train the judges who would be involved, and really communicate with the public about our expectations. The second feature of our environmental court, which is really important, is that the legislature decided that real judges, normal judges, would actually be appointed to be environmental court judges. So the judges of our environmental court are designated by the Supreme Court as the environmental court judges at 2 levels, which I'll explain. So that means that these are judges who have gone through the exact same process of nomination and appointment and confirmation as all the other judges. So that's a real benefit. They have the full power, authority, and foundation of all the judges in our state. A little bit of a downside is they take these environmental responsibilities on top of their other normal responsibilities, and that's one of the challenges we're facing. So one of the first steps that happened is the state Supreme Court designated who would be the environmental court judges. So let me go back and explain a little bit about Hawaii. Hawaii is an archipelago, a series of islands. So on the different islands, we have different courts, different jurisdictions. So on each of the major islands, an environmental court judge was designated at the district court level, which is the trial court level dealing primarily with criminal matters, and then at the circuit court level, which is the civil and sometimes criminal level dealing with major civil trials and felonies. So these are the 2 levels where our environmental court operates. So on each island, we have the designated judges. That's a positive because for us, each island community has its own prosecutor, its own enforcement officers, and its own culture and context. So having that diversity in jurisdiction is really important. A weakness of that system is that it's very hard to keep those judges connected. Even though it's only a short flight between the islands, it does take a lot of resources to pull the judges together for training and for sharing information. So I'll talk about that a little bit later. So in terms of structure, we have the district court level, which is criminal enforcement, the circuit court level, and those constitute our environmental court. And it all became effective in July 2015. At our appellate level, we have an intermediate court of appeals and the state Supreme Court. Technically, they are not part of our environmental court, but they hear the appeals of any cases that go up. And they are very attuned to the need to focus on environmental issues. So in these 4 layers of our court, we have now, since July 2015, a lot of focus on doing a better job at handling environmental cases. Let me explain a little bit about how that works. So at the district court level, which involves criminal matters, for example, if someone is fishing in an area that's protected, where no fishing is allowed, and an enforcement officer catches the violator, that case would be flagged as an environmental court case and then be sent to a designated environmental court judge. And then in theory, that judge would hear all of those fishing cases maybe on one day. We jokingly call this, maybe it's Fish Fridays, when all of the fishing violations are heard by the same judge on the same day. One of the goals of the environmental court was to achieve consistency among the decisions that our judges render, and to provide specialized expertise to the judges that they can apply to their decisions. So making sure that these cases, when they come into the system, are assigned to a particular docket or day or concentrated calendar is really important. The second thing that happens is we try to make sure that the judges are very knowledgeable about the violations that they're hearing. So a major feature of environmental court has been training the judges. And in particular, the current judges have gone through 2, 3, or 4 series of trainings where they hear from prosecutors, enforcement officers. They learn about the fish, they learn about how netting works, they learn about illegal activity. And so they're much more ready to hear these cases. And as a result, the penalties have increased. And the other thing is the judges have asked, and the legislature granted them the authority to sentence violators to an educational course so that we have an ability to rehabilitate them, to change their behavior. And also the legislature provided the court the ability to sentence violators to community service. So these are new. This occurred after the environmental court was established. So now judges have a toolkit. They can fine a violator, send them to jail, require they do an educational course, or sentence them to community service or some combination thereof. So that's part of how our court is developing, to give judges more tools to change behavior, because they don't want to just fine a defendant and send them to jail, particularly over minor violations. So let me talk for a minute about, that's the district court level, about the circuit court level. So this second layer, where we have designated environmental court judges, focuses on civil litigation and particularly on environmental review. So the environmental review process in Hawaii basically means when there's a major project by government or by some private developers, let's say a hotel resort or a airport expansion, then it has to undergo an environmental review process. So if that process is challenged in court, typically by a citizens group, that would go to a designated circuit court judge. And what we're finding in the last 2.5 years since our court was established is the judges around the islands who have those cases are developing a lot more expertise. They're sharing information about how to handle these cases. And we at the law school have been assisting by providing training to the judges on how these environmental review cases work. So there's a lot more focus both at the circuit court level and the district court level. Let me now transition to some of the strengths and weaknesses of our system in Hawaii, because even though we're very proud of it, it's definitely an innovative model. It's not perfect by any means. So to summarize, some of the strengths are we have judges of general jurisdiction, they're well trained, and they're very committed to focusing on environmental issues. They very happily engage in the training, and here I must say that it's been very important as part of our training for the judiciary, for the environmental judges, that they know they're part of this global network of green courts or of judges interested in environmental law. So the World Commission on Environmental Law and now the Global Judicial Institute on the Environment are part of this global network, which makes our judges in Hawaii, again, which is a very small, isolated state, feel like they have colleagues around the world, and gives them more motivation, more confidence to rule, sometimes in a way that can be controversial. So this is really important, that environmental court judges feel that they're part of a global network. So again, this is a real strength of our system. Another strength of our system is that the enforcement agencies are really working closely with the judiciary to provide these tools, and the legislature is working closely to provide more tools to the court. So we're definitely moving in the right direction. Let me talk about some of the weaknesses. Our environmental court does not have a building, does not have any dedicated staff, does not have any dedicated funding. So in a sense, these judges are asked to take on this additional responsibility without any additional help. So at the William S. Richardson School of Law, we have taken on the responsibility, in Hawaiian it's called kuleana, to assist the judiciary. We have been providing our law students as clerks. We have a postgraduate fellowship program where some of our fellows work directly with the enforcement agency and the court to make sure that cases are well prosecuted. We provide some of the training, and we're working with the judiciary on basic tools like a website that can report the decisions that are being made, that will track information for the public and provide more information for the court, and an annual report. So when we think about the features of an environmental court, it really should have all of those things. It really should have dedicated staff, some dedicated funding for travel and training. It should have a website. It should be reporting to the public, so it's a transparent process. So we're lacking some of those features, but definitely working toward it. So in conclusion, what I would say is Hawaii provides an example. It may not be perfect, but an example of how even very small jurisdictions can move toward an effective environmental courts model. Let me finish by talking about how we hope to be a bit of an inspiration to other states in the United States. So as I mentioned earlier, only Vermont and Hawaii currently have environmental courts. We think it's a positive development. So we actually will be partnering with the state Supreme Court in Vermont and their environmental court to hold conferences in the future to try to encourage other states in the United States to adopt this model. And we know that Oregon, California, and Washington in particular are interested, and we hope that other states will be as well. Particularly in the United States right now, we are under a lot of stress politically. Let me just say that's a bit of an understatement, particularly when it comes to environmental issues. So when there is weak leadership at the federal level, which is quite evident now at the executive and the agency level, the states must step up. And environmental courts provide an opportunity for the states to step up their enforcement of environmental laws. Last, let me comment about citizen involvement in this whole process. Our environmental court would not have been created if it weren't for the dedication and passion and energy of non-governmental organizations in Hawaii, grassroots organizations that really wanted to do more to protect our precious environment in Hawaii. And thanks to them, we now have an environmental court that is embraced by our judiciary, by the legislature, and by the executive branch. But going forward, it's important in our jurisdiction and in every jurisdiction that citizens continue to be vigilant, to press for resources for the environmental courts, and to provide transparency in the process. We are aware, unfortunately, that in other jurisdictions, when environmental courts have made decisions that are courageous, that there's been pushback, perhaps from the legislature or the executive. So environmental courts are like a plant. You can plant the seed and it will grow, but it needs to be nourished. And citizens groups and institutions like the law school, our role is to continue to nourish that environmental court to make sure that it's maintained for the future. So I hope you've enjoyed this story, these insights into this one environmental court in the United States, and I hope you'll continue to follow the story of how we're doing with developing these systems both in the United States and around the world. Thank you very much. In Hawaiian, the word for thank you is mahalo. So I say mahalo, and thank you for this opportunity to share this information with you. Aloha.